Everything explained in this video is summarized from the CoinMarketCap. And also, please don't forget to like and subscribe to my channel for future XRP news and some other cryptocurrency news in general. Now, take a look at this. XRP Ripple CLO dismisses settlement rumors, outlines next steps. The discussion over a possible settlement in the legal dispute is cooled down as Stuart Alderati clarifies the continuing SEC v. Ripple litigation. As speculation about a pre-trial conference in the SEC complaint grew, Ripple CLO ended it. Many people in the XRP community were hoping that the conference would lead to a settlement that would end the long legal dispute. Magistrate Sarah Netburn will preside over a last pre-trial conference as per the court's scheduling order issued last year. Pre-trial conference, Alderati rejects the idea many XRP fans were hoping that the pre-trial conference would mean that the lawsuit was getting closer to a settlement, but Ripple's chief legal officer, Khaled, put an end to that after the SEC dropped all accusations against individual defendants, Brad Garlinghouse and Chris Larson, chairman. Alderati announced that the last pre-trial session would not go forward as scheduled. The following actions, the next steps in the SEC case, were also addressed by the Ripple CLO. According to Alderati, Ripple will respond to the SEC's brief on remedies, which demanded a penalty of approximately $2 billion. Importantly, the motion, however, will be submitted under seal, and a redacted version is anticipated to be presented in the public docket. Later on, Alderati brought up the fact that is also when the SEC would submit its response to Ripple's opposition. Debate over settlement soars recently. There have been many discussions on whether or not the SEC v. Ripple lawsuit should be settled. This follows a settlement conference that was convened by the involved parties. Some XRP aficionados have hypothesized that a settlement in the lawsuit could happen soon, even though the conclusion of the meeting was unknown at press time. These speculations were already well grounded before the recent April 11th closed-door meeting of the SEC. In addition, prominent XRP user Ashley Prosper laid forth numerous arguments as to why the SEC versus Ripple case is likely over, one of which is the postponement of the distribution of 500 million XRP from escrow. Rumors circulated among cryptocurrency investors at the time that Ripple was planning to liquidate their holdings to pay off its settlement. The 500 million XRP that were released from escrow were part of the 1 billion coins that were supposed to be issued this month. The system only unlocked 500 million XRP on April 1 due to an issue with the escrow address. The remaining 500 million XRP were unlocked. The spotlight has shifted to Ripple's answer to the SEC's remedies brief as Alderati's latest tweet quells the extensive settlement rumors. Disgorgement should only be paid to institutional clients who sustain financial losses from their XR purchases, according to Ripple's interpretation of a finding in the SEC versus Goldville lawsuit, which is based on a case from the Second Circuit. If the judge rules in favor of Ripple, the corporation will only have to compensate institutional investors who purchased XRP at a price higher than its current market value for disgorgement. As a result, the massive $2 billion fine that the SEC demands could be significantly reduced for Ripple. In the XRP lawsuit that Ripple Labs and the United States Securities and Exchange Commission are now engaged in, speculation surrounding a potential settlement has been received with skepticism and outright dismissal by several legal experts who are actively observing the issue. As a result of a recent court finding that mandated Ripple to provide detailed financial records linked to its institutional sales of XRP, this new development has occurred. This decision has inadvertently stoked rumors of an imminent settlement. An 8-day delay in the legal proceedings has been introduced as a result of the recent court directive that was issued by Judge Sarah Netburn. This has provided Ripple with an extension to meet the criteria for financial disclosure. There's been a lot of conjecture among spectators regarding a possible settlement as a result of this extension. On the other hand, even though the deadline for rebuttals in the remedy stage is scheduled, a definitive conclusion to this tale is still a long way off, which will create a shadow of uncertainty over the next few months. Why a settlement between Ripple and the SEC is nonsense. The settlement allegations have been debunked by legal voices inside the XRP community, which have been vociferous in their denial. A seasoned attorney named Bill Morgan stressed the confidential aspect of settlement negotiations, pointing out that people may not understand that settlement negotiations are confidential and subject to a form of privilege. It is possible that people might not comprehend this. Therefore, there is no indication that a settlement is ever going to be reached until it is abruptly reached. Jesse Hines, Another legal expert expressed her agreement with Morgan's comments and strongly rejected the rumors as being without foundation. Any speculations of a settlement between Ripple and the SEC are nothing more than gibberish if and until a settlement takes place. Not only does this not become public knowledge, but when settlement talks do become public knowledge, it is typically in the guise of a power play move for leverage. Hines said, "Do not put your faith in the nonsense." Mark Fogel, a retired securities lawyer, added a dash of cynicism to the conversation by making fun of the idea that there could be leaks in such high-stakes legal proceedings. In the past, when I was involved in litigation with the Securities and Exchange Commission, he always made it a point to contact a random anonymous Twitter account before beginning settlement negotiations. Simply felt like a matter of basic decency. Fogel commented, underlining the fact that it was highly unlikely that sensitive information would be disclosed. In addition, Morgan stated that in 26 years of settlement negotiations, which included several hundred mediations, either in my capacity as a lawyer or acting as a mediator, there has never been a single instance of a leak or breach of the without prejudice privilege that is attached to the mediation or settlement negotiations by any party or lawyer. Ripple has been confronted with substantial legal hurdles ever since the lawsuit was initiated in December 2020. The Securities and Exchange Commission, SEC, has been examining the company's institutional sales of XRP. Despite the turbulent legal environment and the subsequent negative influence on the performance of the XRP market, Ripple has been successful in obtaining important victories in these cases. Among these are the decision of the court that XRP does not constitute a security and the dismissal of the action brought by the Securities and Exchange Commission against Ripple executives Brad Garlinghouse and Chris Larsen. As a result of rumors that a settlement has been reached, the protracted legal struggle that Ripple Labs and the United States Securities and Exchange Commission have been engaged in may soon conclude. Despite these rumblings, the price of XRP has dropped by about 3% over the past 24 hours, extending its downward trend that has lasted for more than a month. On the other hand, there is a possibility that the existence of a settlement could be some good news for investors who are waiting for the cryptocurrency to return to its previous shape. A rally that could occur just in time for the highly anticipated Bitcoin halving event could be brought about by the conclusion of the case brought by the Securities and Exchange Commission SEC. Ripple XRP aims to reach 60 cents in April as the SEC case, and having get underway at the opportune moment, Ripple and the SEC might have reached a settlement agreement. A big legal struggle has been going on between Ripple and the Securities and Exchange Commission SEC for the past few years. After several encounters between the two groups, the former has emerged victorious on multiple occasions. The information that has been provided is not intended to be trading advice. There is no responsibility for any investments that are made based on the information that is provided on this page. Before making any decision about investments, we strongly advise conducting independent research and consulting with a knowledgeable professional.